Anybody. So, Ben, you're on the ballot for the Kenton County Family Court Second Division. You talked about reforming the system and the need for this. But what are you talking about specifically? Come on, man. You know, out with it. Okay, that's fair. That's more than fair. Okay, and I want to answer that question, and that's the purpose of this video. Now, it's a little sensitive, okay, for me to do that. First of all, there are a number of reforms that I think we can make. All right, they can all fall under the umbrella of doing better about following the rules. Okay, let's understand, for those of us who aren't lawyers, that everything that is associated with a court of law is prescribed by the rules. Okay, there's nothing to fill in. We have rules of procedure that dictate what happens and when, how we do things. Okay, everybody has rules. We have rules for attorneys, rules of professional conduct that say what we can do and what we can't do ethically under the rules. Okay. There are rules binding on the judges, the standards of judicial conduct, okay? And those standards are also indirectly, at least, applicable to the court staff. It makes the judge responsible for the court staff and what they do, okay? And then, of course, there's the law, right? All these things play a critical role in a court. So it's never like a big huddle where we have to figure out what to do, okay? The rules prescribe that, and the way this works is that, you know, if somebody wants something from the court, you have to, or should have to, provide legal authority for your ability to get, you know, to move the court, okay? Legal authority for the court's ability to grant you the authority, or grant you the relief that you're seeking, whatever you're asking the court to do. It has to have authority for you, it has to have authority to do it, okay? And then there's sort of a test or a rule that the court uses, and it takes the facts, the admissible facts, okay? Because again, there are rules of evidence, and those are really important. Okay, the rules of evidence presuppose that there is information that, you know, if it comes before the finder of fact, at family court, the judge, okay? If it comes before the finder of fact a certain way, okay, it's going to not help reveal the truth. It's going to help, you know, it could be misleading, right? And there's certain information that by its very nature, we've said, okay, this is not reliable stuff. So we don't want the finder of fact to see it. And that's the purpose of the rules of evidence. More rules, okay? All of these things have a very important function. I mean, a very important function. So at any given time, all we're doing is consulting the rules, okay? And taking the facts, the admissible facts, the rules of evidence, applying them to the test to see if whoever is moving the court, if it has authority to do so, should get whatever they are asking for, if the court has authority to give it, okay? And there's a test. I mean, it's really like that, okay? So what it is not is a big group huddle on what everybody should think, what everybody thinks should happen. Well-intended or otherwise, that is a prescription for just a total nightmare, okay? Why am I talking about this? Because the reforms that I think are necessary are those that are, that would move that form more towards the kind of system that I just talked about, as opposed, the former, a rule-based form, as opposed to a, for lack of a better term, group huddle-based, you know, system, okay? That's kind of a general idea, right? But let me talk about something like very specifically here that, in my view, is at the top of the list of things that needs to be reformed. This is a sensitive topic, okay? And again, I emphasize the purpose is positive change, not to get anybody in trouble and not to take shots at anybody. It really isn't. It really isn't. People invested in the system have really come after me, and you know, I've got no interest in that. There's nothing productive in going back after them, okay? So here's what I have to say about this. Guys, the business of a court is done on the record, pursuant to the rules that I just discussed, and in conformance with the law, which is really the test, the legal test I just described. There is, to my astonishment, genuine astonishment, based on my experience as a lawyer in litigation, a back alley at the Kenton County Family Court. I've referred to this many times. What I mean by that is that one of the rules that applies to judges on their side, lawyers on lawyer side, okay, is that we do not have traffic. As a general rule, communications to and from lawyers with business before the court and the court itself and its staff are prohibited. There are very limited circumstances under which that's permissible, and those circumstances generally include administrative and scheduling type matters where what you're doing is just attending to housekeeping items. You're not dealing with the substance of the case, and you're sure as hell not arguing the merits, okay? Ex parte communications, it's Latin for without the other, are almost always prohibited, okay? Virtually always. Those are a big no-no. The problems are obvious. You know, these are rules that on the lawyer side, okay, the rules of professional conduct, and there are rules on the judicial side and the standards of judicial conduct. Guys, these are very important rules. And one of the biggest reforms that I think is necessary is a recommitment. Let me be very nice about this. A recommitment to following the rules regarding communications with the court, okay? Because when those rules don't get followed, and in my experience, over a hell of a sample size, okay, my observation is, to put it mildly, that forum isn't where it needs to be, to put it extremely mildly, in terms of following those rules. When that happens, all of a sudden, when you have lawyers more or less arguing their cases or aspects of their case or things that can affect their case, hey, when's my hearing? Hey, when's that order coming out? Hey, all this stuff. Copying the judge in some circumstances. When that happens, all of those types of things, I respectfully submit, are completely inappropriate under the rules and things that I've never seen before in my practice. Now, granted, overwhelmingly I practice in federal court, okay? I can tell you, sincerely, that if any email like that, of the kind I just mentioned, were sent in any of the cases that I'm in, with any judge that I've ever appeared in front of, it would not be a good day for the lawyer that sent that message. And if somebody at the court endeavored to communicate, even responded to something like that, a staffer, bad day, okay? We really need to do this, because when that kind of stuff is happening, it's happening off the record, okay? It's not, no one sees it. Those issues aren't part of the record on appeal. There are no rules off the record. That's why we do it on the record. And when you have that kind of circumstance, there is nothing to prevent there being special favorites and special favors. And in the back alley, if there are special people that get to cut to the front of the line or get to, you know, if there's these communications, that's going to be a big problem, guys. And when you have a system that lends itself to favoritism, the haves are going to have, and the have-nots are going to have not. It's just that simple. So, recognizing that what I just said could be controversial, okay, I am emphasizing again that my purpose is not to take shots at anybody. I'm not using names, okay, and it's not to criticize, but simply to advocate for reform of the system, the elimination of the back alley, a return to what I think aptly characterize as the rules, the rule of law, such that we forever, that there's no concerns about the administration of justice being influenced by the back alley. And if I end up, God help us all, as the next judge at the Kenton County Family Court Division 2, I can promise you that back alley will get shut. I mean, I'm not even kidding you, within 5 minutes of taking the oath of office, okay? If the rules permit, I'm not familiar with them yet, I'd have to study them, I would issue a memo to any and all litigants and attorneys appearing in that forum, making very clear what my expectations were, copying and attaching the relevant rules and laws, and making very clear the violations of that provision, those rules, would carry the most significant sanction. And the first attorney that pushed my luck on that, okay, pushed their luck on that, would have a consequence, okay? And that would be the case if they were my best friend, all right? So, likewise, I would assemble a staff that would, internally, we would have some very clear expectations about, my expectations about what's permissible and what's not. They would be on the lookout for communications from attorneys that were offending, and I would know about that stuff and like right away, okay? And they would not engage that back alley. And if the staff don't engage the back alley, okay, no matter the attempts of private lawyers to establish one, we're not gonna have a problem. I can control that. I can tell you anybody working for me is gonna have a zero tolerance policy about that. So I just wanted to speak more specifically to the kinds of reforms that we need. It's not important to me that I'm the next judge down there. It is important to me that that forum evolve. Again, I'm being really nice here, into something that I think is more consistent with what I know the court to be, which is a rule-based, law-based, no back alley, no preferential justice system. And that's the reform that I'm talking about, at least one. I hope you all have a great day. Really do. Thanks.